A non-compete agreement is any agreement. I don't care whether it's a clause in a handbook or whether it's a contract that you're forced to sign, but it's really any agreement at all that restricts your ability to go work for a competitor, to go work for another company. These agreements are pervasive. They're everywhere. You may not even realize you signed one. A lot of our clients come to us and tell us, I don't think I signed a non-compete. But when we dig through their paperwork as part of their lawsuit against a company, we find it. The reality is that a lot of companies in Washington think that they can bind their workers to these illegal non-competes to prevent them from going to work for somebody else. It's highly illegal. It's absolutely against Washington state law. And we're happy to sue any company that thinks it can bind its workers to a non-compete without paying them the cost of that non-compete. They're not enforceable, except and only if a company pays the worker for it. I don't care what the employer says. I don't care what threatening letter the employer gives an employee about how they're going to sue them if they go work for a competitor. It's really simple. If a company isn't willing to pay a worker 6 figures, they can't have a non-compete contract. There's just no ifs, ands, or buts about it. If you're stuck within a non-compete agreement that you signed before January 1, 2020, you can't sue your employer for it, unless your employer tries to enforce it. If you sign any non-compete after January 1, 2020 that restricts in any way your ability to go work for whomever you want to, for whatever company you want to, you can and you should sue your employer. Because they're not just doing this to you, they're doing this to everybody else too. It's the right thing to do to file a lawsuit. For the last, 50 years, employers seem to think that if they give you a job, if they benevolently hire you, that they should be able to restrict your ability to go work for somewhere else. But employers taking this liberty, trampling the rights of workers, it's asinine, it's illegal, and I think that anyone who's willing to stand up for themselves and willing to stand up for their coworkers is doing everybody a service by taking their employer to task, making them change these practices once and for all so they don't do this to other people. A much smarter person than me once told me that an individual who represents themselves has a fool for a lawyer. I mean, the bottom line is these disputes, they're pretty complicated and it's a battle almost every time because for some strange reason, defendants don't want to change their practices. These large companies that are taking advantage of workers and making them think they can't go work for competitors and keeping them longer than they should be based on a contract, they don't want to change their practices. So I think that anyone should expect a bitter, hard-fought battle when they file these lawsuits. That's why people like us exist, because we're really good at winning these lawsuits. We believe wholeheartedly that any company should be able to keep its workers not based on a contract. They should just be able to keep their workers because they're a good place to work. Out of all the firms that have brought lawsuits based upon 4962 and the non-compete statutes, I would say that this firm is an absolute leader in winning these types of cases. And in fact, we have a case right now that'll be heard in the Supreme Court, and that's very much a direct result of our pushing this statute and pushing it hard.